Hello, I'm here with the backstory, the Washington Week backstory, where we ask our panelists to take us behind the scenes of the stories they've been working on. Tonight, Joan Biskupic of Reuters joins us to talk about a really interesting, kind of deeply reported project that you all did about who gets to argue before the Supreme Court. I don't think we give, it's one of these cases of things we haven't thought a lot about, but it turns out it's a very narrow, very self-selected group of individuals who get to make the arguments to people with similar backgrounds.
I'm glad to be able to answer that, Gwen, because if you sit there, day after day in the courtroom and you read petitions day after day, you start to see that there are certain names that keep coming up over and over. And I'd noticed that there had been a contraction in the lawyers who seemed to be appearing more both in written briefs and at the lectern in the court. And what Reuters decided to do was to test that with data. So we went sort of on two tracks over the last 18 months. One involved my talking to all the justices and
all 9 justices.
Well, 8 spoke on the record. The Chief Justice of the United States, John Roberts, did not speak for the record. So, but I did talk to the other 8. And then also lawyers involved, litigants, clients. And then we tested it with data. We looked at more than 10,000 petitions, which petitions for certiorari are what launch a case before the Supreme Court. We normally would refer to them as appeals. They come up from the lower courts, and the justices themselves have total discretion over which cases they want to take. And we found that the success rates of 66 lawyers were remarkable. 66 of essentially 17,000 lawyers who we studied. And we isolated first on these 66 lawyers who were most successful in the petition rate. We found that of the 66, all but 3 were white, and all but, I think it was 6 or 7 happened to be male and happened to also be, have experience either as a former Supreme Court law clerk or had worked in the prestigious office of the Solicitor General.
Now you say happened to be, but these things don't happen by accident.
Right.
So I wonder whether it's, it's a chicken and the egg question, I realize, but it's because the justices see these names on these petitions, or it's because they've figured out the game, how to write a petition that will get heard, that will get picked up by the court.
It's a combination, I think. I think that these people who've worked behind the scenes as law clerks and who are repeat players, they know how to write a petition that the justices want. They know how to do it. But the justices also have confidence in certain names and certain people. When I talked to the justices, I said, does it bother you that you don't have a more diverse crowd before you, both at the lectern and in these petitions? And to a person, and especially including the liberal justices, said, no, we're not picking the lawyers who come before us, and we are looking for a certain kind of expertise. We're looking for a certain kind of professionalism. And if clients are choosing people who are familiar to us because they've either worked for us or they've had the experience in the Solicitor General's office, that's not our problem. We're looking to people who actually can speak our language.
Some people would call that elitism, but maybe that's the way that we have structured our legal system to work?
What Justice Ruth Bader Ginsburg said was, this is a highly specialized kind of work. There is a natural sort of elitism rising to the top. It's part of what this system is all about. And Justice Sotomayor, our first Hispanic justice on the Supreme Court, said similar things about if we get people who are coming more from the trenches, people who haven't argued before, who might offer us more diversity, they might not give us the kind of specialization that the justices want.
And what did Justice Thomas say to you about this?
Justice Thomas said the same thing. He said, I'm not looking for particular names, but if I see a brief written by Ted Olson or by Paul Clement, 2 regulars before the Supreme Court, I know it's going to be good. And they also count on these lawyers for a sort of screening effect. Justice Anthony Kennedy, for example, said to me that, if one of these corporate lawyers are bringing the case, they've already sort of screened out the bad ones. That was the other thing we found, Gwen. Not only did we have a certain kind of insularity, we also had a real corporate tilt among the 66 who were most successful in the petitions. And that was also mirrored in the core 8 lawyers, again, all white men, who argued the most before the justices in the last decade.
I guess the question, and maybe this is not an answerable question, is whether they're also screening out worthy cases because they're not brought by someone who's a member of the club.
That was exactly what we tried to get at. We tried to look at, who could be the losers here? Are there some costs and consequences? And in a broad way, people were saying to us, look, aggrieved workers, consumers might not be able to get this kind of representation because most of these lawyers are representing corporations, and they would have a conflict of interest to then represent somebody who would be challenging a corporation, natural lawyer conflict of interest. But it's very hard to point to a particular case that should have been taken.
Yeah.
And I'll tell you why. Yeah, I mean, and you know this because you know how many petitions the justices get. They get literally thousands of petitions each term. And over the course of all this, we looked at more than 10,000 petitions for the last 9 years, which, John Roberts' early tenure. And, most of them don't deserve to be taken. So it's hard to say you should have taken that case.
Right. It's also proving a negative. I don't know how you do that.
It is, because the justices themselves have complete discretion, and they're going to look for cases where there's been a split in the circuits below, where lower courts have differed. And they also might even bypass a certain case where their courts actually diverge in their ruling, and they in other situations might want to have a uniform standard because the facts aren't good, or it might be flawed in some way. There might be some mootness issue. So they want a case to be perfectly teed up, and these lawyers know how to tee them up.
Well, 10,000 petitions that you looked at over how many years? 9 years?
Yeah.
That's a lot of work. We want to thank you for that, Jo.
Right. Well, it was our data people. I don't want to take credit for all the work they did.
The data people gave us an insight into the Washington Week backstory. Thank you a lot, and thank you all too.